Major upset in Kano State as election petition tribunal sacks Governor Abba Yusuf of the NNPP, declares Nasiru Gawuna of the APC as a winner of the governorship election. President Bola Tinubu asserts Nigeria and Africa's place in the world in his inaugural address on the floor of the United Nations General Assembly. Says Africa is not a problem, but the key to the world's future. Hello and welcome to Politics Today, live on Channels Television. I'm Kaido Kikelu in Lagos. What a day it turned out to be. All eyes on Kano State in the aftermath of the judgment by the Governorship Election Tribunal, which sacked Governor Abba Kabir Yusuf and declared the All Progressives Congress's candidate, Nasiru Gawuna, as the winner of that March 18th governorship election. Well, Kano State in northwest Nigeria is one politically intriguing state. It is one to always watch out for, really. Its election history has always been dramatic, and this year it would seem lived up to that billing. Well, today's judgment was delivered not the usual way, with the judges seated physically. Instead, the three-man panel chaired by Justice Oluyemi Osadebe opted for a virtual sit-in via Zoom. Now, here's what played out. The court deducted 165,000 votes, that's 165,663 votes from Mr. Yusuf's total as invalid votes, stating that the affected ballot papers were not stamped or signed and therefore declared invalid. The court then ordered the withdrawal of the certificate of return which INEC presented to Mr. Yusuf and directed a certificate of return to be issued to APC's Gawuna. Well, security has been beefed up in the state in the aftermath of that judgment, which the lawyers to the respondents, that's the NNPP and the governor, say will be appealed. We'll take a listen to some sound bites from after that judgment, and we'll be back for more.
They said that the petitioner's petition was succeeded, and they declare the candidate of the petitioner as a winner of the election, even though it's not a party to the matter. There are so many things in the matter, but the tribunal has said its own. We are going to consult our client, and then I can assure you that we are going to appeal against this decision, and I can assure you that this decision will not stand at the Court of Appeal.
We filed this petition to show that, and clearly we have demonstrated it by bringing in invalid ballot papers, 165,000 of the ballot papers, and the court went through these ballot papers one after the other and confirmed that these ballot papers were not signed, stamped, and dated. And the law says it shall be signed, stamped, and dated. So all these three must be there, not two, not one. All the three must be there. And the court, of course, accordingly deducted these invalid votes from the votes of NNPP. After doing that, Nasiru Yusuf Gawuna was declared the winner of the election.
Well, that's the big story for the day. Stay with us right here on Channels Television as we bring you responses, analysis, just a deep dive into that judgment, the outcome, the aftermath, what will play out perhaps in the coming days. But it's a much different scenario that played out in Bauchi State, which, by the way, is just next door to Kano, but this time in northeast Nigeria. The victory of Governor Bala Mohammed in the March 2023 governorship election was upheld by the Election Petition Tribunal sitting in the state. The tribunal dismissed the petition filed by the APC's governorship candidate, Air Marshal Sadiq Abubakar, and the APC for failure to prove the petition beyond reasonable doubt, and held that the election of Governor Bala Mohammed was conducted in compliance with the Electoral Act 2022.
During the trial, you saw they were not able to call witnesses. So all the allegations, there were no witnesses to back them up. The documents they brought, no witnesses to speak to them. So we are very happy that today this has come to an end.
I stood up and I thanked their lordships for their judgment. So, and I begged them, I appealed to them Because we give us a certified true copy of the judgment so that we can give our client who will give us the next instruction to do with the judgment.
Well, the governor himself has been speaking about the outcome of that election, which affirmed his victory in the March governorship election in the state. We'll take a listen to what Governor Bala Mohammed said in the coming moments. And we'll be bringing you analysis, as I said, of the Election Petition Tribunal judgment, particularly the case of Kano. We have Leonard Silks joining us on the program. We have the concerned party as well, who will give us a breakdown of what exactly played out. So let's listen to the governor of Bauchi State speaking now on the outcome of the tribunal which held in his own state.
I solemnly invite my worthy opponents, each of whom is an unqualified success in his own right, to shield their swords and to join me in the collective quest to harness the enormous resources of the state to create a modern economy that would benefit everyone.
So before we get talking about these issues, let's check in with President Bola Tinubu, who has been in New York for, 3 days now, for the 78th United Nations General Assembly. He mounted the podium at the UN headquarters early this morning, Nigerian time, and delivered his maiden address, in which he declared Nigeria as ready for investment. He called for equitable distribution of wealth and the desire for a prosperous Africa. We'll take a listen to part of what President Tinubu said.
For Africa, we seek to be neither appendage nor patron. We do not wish to replace old shackles with new ones. Instead, we hope to walk the rich African soil and live under the magnificent African sky, free of the wrongs of the past and clear of the associated encumbrances. We desire a beautiful, prosperous, vibrant, democratic living space for our people.
Well, the president has also billed to ring the NASDAQ closing bell, so we'll keep our eyes on that one. But back home, we have more trending political stories for you. Here's your political roundup.
The Chief Justice of Nigeria, Olukayode Ariwola, has decried a large number of cases, especially political cases, that judges have to tackle on a daily basis. Religion, but highlight the ability of the candidate of the APC, Usman Ododo, to consolidate and even surpass the current achievements of his administration. He spoke during the inauguration of the Kogi State APC Governorship Campaign Council. And over to the southeast, where the Independent National Electoral Commission, INEC, in Imo State says a total of 134,000 PVCs are still piled up in each of the 27 local government areas of Imo State waiting to be collected. Addressing newsmen at the Commission's office in Owerri, the Imo State capital, the resident electoral commissioner, Professor Sylvia Ago, urges Imo indigents to go to INEC local government area offices to collect their PVCs. She explains that the commission is ready for the state governorship election, as all non-sensitive materials have been received and will be distributed to various local government areas in due time.
INEC Imo State still has many uncollected PVCs filed in each of the 27 LGs of the state.
The Gombe State Governorship State Assembly Election Petitions Tribunal, sitting in Gombe, has nullified the election of the Speaker of the State House of Assembly, Honorable Abubakar Legorowo. The tribunal, presided over by Justice Michael Uga, gave the judgment on the ground that the Independent National Electoral Commission cancelled votes cast in some polling units in the constituency, which the petitioner complained about before the tribunal, that the action gave the defendant undue victory at the March 18, 2023 polls. Justice Uga ruled that that the cancellation of the results of Units 001, 024 and 014 of Kumo East in Akko local government area of the state by INEC was an error and ordered INEC to conduct rerun elections within the next 30 days to determine the actual winner of the legislative seat. The presidential candidate of the Accord Party in the 2023 presidential election, Professor Christopher Imomulen, is applauding President Bola Tinubu for the steps taken in the appointment of youth in his administration. In a media briefing on the state of the nation in Abuja, Professor Imomulen says the huge population of youth is a plus to the country and the present government needs to take advantage of the numerical strength of the youth to create wealth. He, however, warned the youth to imbibe the values of hard work, discipline and honesty to become great leaders.
I am kind of very satisfied and optimistic with the way the Nigerian youth have been appointed. Look at the current appointment of the essays. You see, 80 to 85% of them are young persons who are little above the age of 32, 30 years.
The gavel dropped today in Kano State. It didn't go the way of the new Nigeria People's Party, NNPP, and Governor Abba Yusuf. That's the only state that the NNPP won in the last election. So how is Mr. Yusuf, the NNPP, and in fact, Kano State taking this? And just before we get into that, let's get some legal perspective into what the court decided today. Because if you look at the original governorship election result, as declared by INEC as far back as March the 20th, you see that the APC's Nasiru got 890,705 votes. And that's compared to the NNPP, Mr. Kabiru's 1,019,602 votes. That was what INEC declared. But today in court, if we could just show you that breakdown, the court ruled that 165,663 votes be deducted from the NNPP's Kabiru's votes, the over 1 million votes. So that leaves the NNPP's Kabiru with 853,939 votes compared to that of the APC's 890,705 votes. We have a breakdown of that for you on the program, but that gives you a sense of how the judgment swung today, what was decided upon. By the way, not much people were allowed into that courtroom, just about 50 people, including staff and legal practitioners. So it wasn't a full hall. Security was really tight. But let's get a legal perspective into all of this. We're joined by Senior Advocate of Nigeria, Mr. Ahmed Raji, joins us from Abuja virtually this evening. Thank you for joining us on the program, Senior Advocate.
Thank you. Good evening.
Well, good evening.
Good evening.
It's really what is playing out in Kano for a lot of people is mixed feelings. For some, it is shocking, but for legal practitioners such as yourself, Learned Silks, you're a senior practitioner. What did we just witness in Kano State, Senior Advocate?
Well, that is the judgment of the tribunal is to the effect that some of the votes credited to the sitting governor were not properly earned for several reasons given by the tribunal. It is not strange to nullify election. Ngige was in office for almost 3 years. His election was nullified. And that was how Obi got it. But that is not to say that the judgment given this afternoon is final. We all know that the tribunal is just a court of first instance. There is opportunity to appeal to the Court of Appeal and from there to the Supreme Court. And the law allows the governor to remain on his seat while these appeal processes are on. Therefore, it is too early to start putting a banner of finality on what has been rendered today. I think it is an unfolding scenario. We need to tarry a while before we run into a final statement on what has happened. Yes, the effect of the judgment is the governor did not win the election, but it does not end there. That is my reaction.
So just to be clear, as you said, this judgment today does not mean that he ceases to be governor immediately after that judgment was given.
No, no. The law allows him opportunity to appeal. And if he does not enter his appeal within the number of days allowed, then he may be removed from the office. But once he files his appeal within time, he remains in the office. And even if he goes to the Court of Appeal and whatever happens, he loses or he wins, he still has an opportunity to appeal to the Supreme Court. So technically speaking, he has the liberty, the right to remain in that office while his appeals are being entertained by both the Court of Appeal and possibly by the Supreme Court, whatever happens.
Right. So for those who saw the election play out in March, those who participated in the election, people in Kano State who voted and the rest, they saw the result as declared by INEC, which we just showed just moments ago. And now they hear the judgment of the court. How do they reconcile this judgment with the election result that was declared, that they witnessed declared? Because a lot of people don't quite understand how the courts work out, the issues that are determined, whether they are technicalities, whether they are merits of the case. How do they reconcile this so we can perhaps bring the people into the court so they see what is playing out?
Well, the INEC has performed its own role, and the same law that gave the power to INEC to conduct the election and announce the result also gave powers to the tribunal to review whatever INEC has done. In their wisdom, the tribunal members felt that 165,000 votes are not properly earned. They were not earned. And therefore, for numerous reasons, as they have as contained in the judgment. And so, to your question, the INEC and the tribunal, they are not competing. INEC has its own role, tribunal has its own role. INEC is not infallible. It can make mistake. Tribunal too is not infallible. It can make mistake. And that is why we have the Court of Appeal, and that is why we have the Supreme Court. So, strictly speaking, the way to put it is, INEC has performed its role. Now tribunal has set in to say, no, you're wrong. And which the Constitution, the laws of the land, that gave the power to the tribunal. So there's really, strictly speaking, nothing to reconcile. Because INEC is not infallible. Only God is infallible. Only Almighty Allah is infallible. Therefore, they can make mistake. And tribunal is given the power to look into all the facts and come to a conclusion and redress wrongs. And if the tribunal too makes mistake, the Court of Appeal is there. And perhaps the Court of Appeal too falls into error. The Supreme Court is the final arbiter. So let us put it, that is the way I will put it. I won't say that there is nothing to really reconcile. Each is performing his own role. That's all.
Well, let's bring in another senior advocate of Nigeria. Let's expand this conversation. We'll have more join us during the course of the program. We're joined by Mr. Kayode Dilola, who's also a senior advocate of Nigeria, joining us from Lekki in Lagos this evening. Thank you for joining us on the program, Mr. Dilola.
Thank you very much for having me.
Well, I know for lawyers, the way you interpret these things will definitely be different from how, well, the people who are not lawyers, who do not practice, talk more of at the senior level of the profession will see this. But, looking at the judgment of the court, the tribunal deducted 165,000 votes from the NNPP as candidate. Is it curious, perhaps you add this to your opening comment as well, is it curious for you that nothing was deducted from the APC candidates?
Now, let us look at it this way. Whenever you have a matter before the court, they listen to the evidence of the parties, they look at the pleadings that you have filed, and see how you have been able to address the issues. The evidence before the courts must have necessitated their deduction of the votes. If the other party had convinced them also that some votes were ascribed to the APC candidate, they probably would have done so. You see, we should not assume that judges take decisions without considering what the evidence for them are. They look at the evidence and, of course, put them side by side the pleadings before them. Now, it's not a question of you deduct from so-and-so, you must deduct from me as well. The evidence must have shown that in certain polling booths or in certain polling units, the votes cast there were meant for the APC candidate and not the NNPP candidate. However, like my learned brother had just said, this is not the final, the tribunal that has heard matter is not the final arbiter. And so we're going to wait for the Court of Appeal to have the benefit of having the final say. Well, I say not the Court of Appeal, but the Supreme Court, if they do have the opportunity of going before them. But in the meantime, this is the decision of the tribunal going by the evidence that was placed before them and as they understand it.
So I'd like us to also speak about the factors that surrounded today's judgment. The judge, or at least the judges, the panel, they didn't sit physically. They had to sit virtually via Zoom. And for a lot of people, it was a curious case. COVID-19 came with that option. I mean, judges started exploring the option of sitting virtually. But we've seen other tribunal cases across board. The National Assembly, governorship, even for the presidential election, it was a physical sitting. So, I mean, when you heard that this was going to be virtual, I wonder what your reaction was, so perhaps others can understand as well. That's for you, Mr. Dilola.
It's not unlawful, and yes, it's not unlawful, and also if the President of the Court of Appeal, who is vested with the responsibility of assigning judges to the tribunals, feels that she has a practice direction that she can sign and say, for this purpose, you can have virtual hearings, it's fine. Like you said, during the COVID, we had sitting done virtually. And even after that, I have attended a few court sittings virtually because it was convenient to do so. As long as the justice of the case is not diminished in any way, there's nothing wrong with it. I know a lot of people will ask themselves, why do you have virtual sitting in Kano? You didn't have virtual sitting in Abuja. Those are the questions that may be asked. But the important thing is the cases must be heard in public. The decisions of the justice of the tribunal or the justices of the Court of Appeal must be heard, and justice must not be diminished whatsoever by virtue of the forum that is used. That's my attitude to it.
And Kano is a politically charged state, if I could use that expression. Quite intriguing when it comes to politics. We saw what played out in 2019. We've seen the back and forth between the major political players in that state. And this is for both of you senior advocates. What kind of dilemma or what kind of situation do you think the judges would have had to surmount or are faced with in coming up with this judgment, first understanding the political situation in Kano State, the effects on security, law and order in the state, and other factors that may arise from this case. So what kind of, dilemma, factors do you think the judges will have considered in the build-up to delivering this? Okay, let me begin with you, Mr. Delola, before I go to Mr. Ahmed Raji.
Yes.
Please go ahead.
Hello?
Yes, we can hear you. Please go ahead. Okay.
Hello, are you speaking to me?
Oh, right.
Yeah. So this is for Mr. Delola. Please go ahead, Mr. Delola, then I'll go to Mr. Raji.
Oh, okay, that's right. Now, again, I'd like to tell you this. A judge will not sit at the bench and ask herself or himself, should I give judgment in this way or the other, all because of what the reaction of the people will be. The first thing the judge ought to do, or the tribunal, is to consider the facts and the evidence that have been placed before her. These are the primary considerations. Otherwise, that judge will be shirking her responsibility and her oath of office, where she has sworn to deliver judgment without fear or favor, ill will, or affection. If she considers the fact that some people are going to be unhappy with her judgment, and she determines the outcome based upon that, that cannot be justice. We must consider the fact that judges have a responsibility to God, to the judiciary they serve, but more importantly, to the law that they have been called upon to uphold. However, we have realized that the Supreme Court, for example, which ultimately will be the final arbiter, like we usually describe them, is not only a court of law, but also a policy court, because they have a responsibility to ensure that there's a balance, and they do that at that level. But with a tribunal must simply look at the pleadings, look at the evidence, and come to a conclusion. That's my position.
Okay, let me take this to Mr. Raji. I should mention now that we will still have joining us the NNPP speaking on this case. They are the respondents in this matter. They are the concerned party, and we'll be hearing from them. But let me go to Mr. Raji and get your thoughts on that point which I made about, the state of Kano, the factors that surround politics in Kano, and then the judge's decision.
I beg your pardon, please?
The same question to you, Mr. Raji. I was asking what kind of dilemma do you think the judges faced in the build-up to this judgment, considering the situation around Kano's politics, security, and the rest?
My learned brother has answered you adequately. The judges are concerned with the law, the facts, and the evidence in support or against the pleadings. So the question of tension or whatever the feelings of the people are may not really matter when a tribunal duly constituted is to render judgment based on the pleadings and the evidence laid. In this case, the question to ask is whether the tribunal was right in coming to the conclusion. And the only way to test that is to go on appeal.
Right.
That is it. That is just the way. I mean, the tribunal has no business with, and I do not think they are in any way affected by what is the feeling of the people, what are they going to say, and all those kind of things. What is the evidence before the tribunal? That is it.
All right.
It's justice according to law,
well, senior
not
advocate,
according to sentiment. Yeah.
Right. Pardon me. We're due for break now. And as I said earlier on, we have joining us a concerned party. We'll be hearing from the horse's mouth, so to speak. We have the National Legal Advisor of the NNPP joining us on the program. But that will be after this break. When we return, Mr. Robert Hon will be speaking on the party's reaction to this judgment, the way forward, and of course, the issues that were decided upon. That's in a moment. So join us again. Well, you're welcome back. We're still analyzing the interesting scenes coming from Kano State in the aftermath of the tribunal's judgment, which nullified the election of Governor Yusuf and asked that the APC's candidate in that election be returned as the winner. We've been speaking with two senior advocates of Nigeria who've been helping us understand what may have played out, Mr. Kayode Adilola and Mr. Ahmed Raji. But let's expand the conversation now. As I said earlier on, we have Mr. Robert Hon, who is the National Legal Advisor for the NNPP. He joins us live from our Kano studio. It's good to have you on the program, Mr. Hon.
Thank you very much, Kayode. I appreciate it.
Naturally, would like to get your immediate reaction to this judgment. You're a politician, you're a legal practitioner, you're a party man as well, but how do you take this judgment?
We take it with a philosophical calmness. We are not perturbed at all as a party, and we are also using this opportunity to call on our teaming supporters, members of NNPP in Kano and Nigeria at large, to remain calm, as there is no cause for alarm. This is just a court of first instance. We have the Court of Appeal, and we even have the Supreme Court. We are prepared to retrieve the mandate that was given to us by over 1 million people of Kano State. You can see that even after the judgment, Kano State is very peaceful. The streets are peaceful. Nobody is agitating over anything. So we are good to go. We will test it up to the last level. We are not in any way perturbed. The issues that we raise, we have the opportunity to ask the appellate court to look at it critically and see whether the tribunal did justice to the evidence that we brought before it.
You know, Kano State is the only state that NNPP won, at least the governorship election in this past election. And seeing the judgment of the tribunal now, yes, there's still the option to escalate this further. But speaking particularly to the governor, how is he handling this judgment?
Sorry, pardon?
This is for the governor now. How is he handling this?
The government of Kano?
The governor himself, Governor Abba Yusuf.
Oh, Abba Yusuf is in high spirits. You see, when you get your mandate genuinely from the people, the legal gymnastics that will play out matters not much to you. The people are solidly behind the governor, and that is the most important thing. The people gave him the mandate. The people are still with him, solidly behind him. And the mandate, I can assure you, will be surely be retrieved. We have confidence in the judiciary. We have trust in the judiciary. And we know that by the grace of God, justice will surely be served.
All right, Mr. Hahn, let's take a look at what the court decided on today as it is on the screen right there. The original result as declared by INEC, and now what the court decided upon, asked that 165,663 votes be deducted from that of Governor Yusuf. And it essentially says that it's as a result of those result sheets not being stamped or signed and therefore were declared invalid. I wonder, what sort of defense did your party put up when this was raised? What was your party's brief like?
Thank you very much. We are much concerned with what we do at the next level. But if I must tell you, the pleadings of the petitioners and the evidence they adduced that are below the standard. But that is, like I said, that is for the next appellate court to decide. But where you are complaining about over 1,000 polling units, overvoting, disruption, violence, killing, and all of that, and you call in only 34 witnesses to testify on the violence across 1,000 plus polling units. It is quite curious. But the tribunal, in its own wisdom, found that the petitioner has proved their case, even where they were alleging violence, killings, disruption, which are criminal in nature. The tribunal still found that they have discharged the burden on them and laid the blame squarely on the first respondent INEC for failing to rebut the claims and allegations of the petitioner. And therefore, the petitioner has proved his case. On the issue of the ballot papers, the issue is when were those ballot papers tendered? Where were they tendered? But I wouldn't want to preempt the case of the respondents. On the media platform, we will go back to our drawing board together with the legal team, which is very competent, and we look at the issues critically and approach the Court of Appeal in due course. Remember that we have 21 days to do that, with effect from today.
Indeed. So speak to us about the point you made about burden of proof being shifted to INEC. Did you expect more from INEC's counsel in this particular case?
Kayode, I must tell you that I never wanted to expose our case. But let me tell you that when you are seeking declaratory reliefs, as in this case, the burden is on you to prove. Where you have not substantially proved your case, for instance, alleging that there was overvoting in over 1,000 polling units, and you call 34 agents, it goes more to say that you have yet to scratch the burden of evidence placed on you, not to talk of discharging sin. And even where, for declaratory reliefs, even where you have not where the respondent has not even said anything or has even admitted, the burden is still on you to prove your case to be entitled to these declaratory reliefs. But like I said, I think I don't want to preempt the legal team of NLPP. I will leave it at that.
Right.
But that is a summary of what we are confronted with in court today.
That's understandable, but I'd like you to speak to the next line of action. How confident are you of securing a favorable judgment at the Court of Appeal, seeing what has played out at the tribunal?
See, the law is good. When you have a judiciary that is balanced, sincere, focused, and you have the confidence in the judiciary, you are sure of victory at any level. May I also add that the framers of our Constitution, the authors of the Constitution, they do that human error, human limitations and inhibitions will come into play when giving judgments of this nature. That's why we have the first layer, the second layer, and the third layer. So we are not perturbed. We feel strongly that given the evidence we have adduced before the tribunal and given the pleadings and evidence of the petition, I think the petition cannot survive the next level. Thank you very much.
So let me take this back to the senior advocates who have been joining us on the program from the very scratch. And I'll come back to you, Mr. Adelola. Well, he has given the side of this, perhaps things that played out. Importantly, he doesn't want to preempt the legal team and, of course, the appeal court. So 21 days counting now. But there's this debate that has been on for a while, and people talk about the propriety or otherwise of courts deciding again on what people have decided on at the ballot. I know there have been different conversations around this, but I wonder if now is a time to also bring this up again and perhaps find a resolution to that debate. Is this how we want it to be moving forward? Do we want to change it? I wonder what your thoughts are.
I'd like to make this point very clear. When a law is enacted, well, let's go to the beginning. Before a law is passed, a statute is enacted by the National Assembly, we are called upon to make our comments. Many of us do not do so. And then when the consequences face us, we complain. The Electoral Act was presented to members of the public. It was sent to the president for assent. There were complaints. He sent the bill back. It was sent back to him again. Whilst this was going on, members of the National Assembly were there. Legal practitioners were listening. Members of the public had access. And some of us don't say anything. Now, what people expect is, the court should not determine who has won the election for us. Who then should determine? Do we want to go to the marketplace and simply ask for opinions or ask for a referendum? We can't do that. If there are issues of law, as of course there would be in an electoral process, the appropriate place to go to is the court. If we do not want to go to the court, they maybe want to set up what we may want to call our electoral college. But until that is done, the situation we have found ourselves is that when there's a dispute in the electoral process, you must go to a tribunal, and in the case of the presidential election, you must go to the Court of Appeal. they will determine, based upon the evidence which we bring, based upon the witnesses who are members of the public, who witnessed the voting, and then they would make a decision. But until that is done, for now, the law is what it is, and let us abide.
It's quite interesting, really, and I'll go to Mr. Raji for this one. The irony there is today as well, the Chief Justice of Nigeria, Justice Olukayode Ariwoola, actually expressed concern over the significant volume of cases, particularly those of politicians, those that are political in nature, which he says are burdening judges. Judges have to handle this daily. And I'll come to Mr. Raji on this one now. Hearing the CJN say that, and also hearing the fact that, well, all of these things can go to court. Politicians keep going to court. He had said it earlier on that, you know, Nigeria's political class are the most litigious. So how do we strike a balance then? We don't want the courts to be overburdened, but this is what we have on our hands.
Well, I think this is a problem which will require us to really do some soul searching so that the number of cases that we take to court, I agree, in other climes they go to court like Al Gore and what have you, but the number of cases we have in Nigeria arising from either pre-election or post-election, I do not think there is any jurisdiction in the world with such a number. I'm not aware. And if anybody has anything to the contrary, let him come out. I think the antidote to that would be a credible election. And perhaps we need to change from this presidential system to a much more moderate system, like maybe a modified parliamentary system. For example, when you look at what it entails to become a governor from primaries and what have you, it cannot be a do or die battle among our politicians. So two things, we need a credible electoral process so as to drop the number of complaints. Secondly, there is an urgent need for us as a nation to move away from presidential system to what I would call a modified parliamentary system. No doubt there may still be issues, but it won't be at this scale and at this level. And the CJN was right when he lamented that the sheer number of cases is really suffocating them. There was a time for almost 6 months, the whole court shut down, but for only election matters. That was the Supreme Court. They were not doing anything. Or it's just about pre-election matters. You have important cases touching on oil blocks and what have you, things that are generating income for the country, real, commercial litigation, tying down money, fund and what have you, that will assist the country and that will present the country as an investment climate that is very friendly. No, it's all about pre-election matters. I think something should be done.
Right.
Something urgently needs to be done. That's my take.
Thank you, Mr. Raji. Let's wind down on this, and I'll go to Mr. Han in our Kano studio. And this, yes, we've talked about the way forward, but we've also seen what has played out in your party, the NNPP, over the past couple of weeks. Is that perhaps something that distracted the legal team, the party, in the build-up to this judgment while handling the case? What exactly is the state of affairs, really? Because we had a group suspended or expelled Mr. Kwakwaso. There was a counter-expulsion or suspension. What is the state of affairs, and how is it taking a toll on the party's activities? One of them will be the appeal now of this judgment.
Kayode, thank you very much. Our party is intact. There is no fracas. There's no factions. What is happening is just an excitement that arose from after the general election of 2023. The party sat down, look at its performance, and see the way, after a post-mortem analysis, of how to restructure the party to move forward and engage in future political activities. In the course of doing that, we have to rejig, we have to prune, and get rid of some dead woods among our party hierarchy. It is those people whom we consider them of no value to the party that, of course, they have the right to complain, they have the right to agitate.
Are you referring to the party's founder, Chief Ani Bonham?
No. I am referring, yes. I am referring to all the people who constitute a nuisance to the party, instead of moving up together in one spirit, to build a party for future engagement, decided to create themselves as stumbling blocks.
Right.
We have to get rid of them, no matter who they are.
Well,
I must say that the party is supreme.
Right. Well, we'll have to thank you so much.
Any person, no matter how well placed.
Well, I think that's a great place to anchor, Mr. On. We're totally out of time. We're still following the case in Kano, and we'll, of course, be speaking with you and your party, particularly the governor, in the coming days regarding this judgment. We'd like to thank you so much, Mr. Robert On, who's the National Legal Advisor of the NNPP, as well as Mr. Kayode Adelola, Senior Advocate of Nigeria, and Mr. Ahmed Raji, also a Senior Advocate of Nigeria. Thank you so much, gentlemen, for the insights, very vital to this case. And that's the show for tonight, everyone. Thank you for watching. You don't know what politics will bring you next, so stay with Channels Television for the latest updates. I'm Kayode Adelola. Good night.